SJC-11979, Marcia D. Bellerman and others v. Fitchburg Gas and Electric Light Company.
Good morning, Mr. Rooney.
Yes, may it please the Court, Your Honors may recall my name is Gavin Rooney, appearing on behalf of the appellant, Fitchburg Gas and Electric Light Company. Upon remand from this Court's decision 2 years ago in what I'll call Bellerman 1, the trial court made 3 errors of law. First, it misread footnote 10 in this Court's opinion as a supposed warranting of class certification on an overpayment theory, when the import of the Court's footnote was that that theory had been waived for appellate purposes. Second of all, by certifying a class based upon that overpayment theory, the Court eliminated the requirement of injury, which is a statutory one under 93A, in order to find that injury essentially arises only from the regulatory violation alleged. And then finally, by allowing the case to go forward on this basis, the trial court allowed the plaintiff to sue for an overpayment of rates that are scheduled and approved by the DPU, the Department of Public Utilities, that violates the DPU's exclusive rate-making role. Let me begin with the footnote. When this matter came before the court the last time, it came from a decision by Judge Wilkins, a comprehensive decision on class certification that significantly was brought after the close of all discovery, fact, and expert. Judge Wilkins, in his opinion, did not address the overpayment theory because it was never presented to him. We went back and searched in depth the trial court record. It was never mentioned by the plaintiffs at that point in time.
But accepting that,
yes.
When it went back, the Judge Tucker, somebody allowed, maybe it was Judge Tucker, allowed an amended complaint.
No, Your Honor. There was no amended complaint.
Or an amended motion for class certification.
The plaintiffs filed a renewed motion for class certification. That is the only thing that happened at the trial court level. There was no amendment to the complaint, even though the theory of the case was different, the class was different.
Well, I guess my point is, it seems to me, quite apart from whether the ultimate decision was correct, it seems to me that implicitly Judge Tucker was allowing the plaintiffs to refashion their theory of class certification.
But I think
and I guess my question is,
yes.
Didn't he have authority to do that? I'm not going to whether he was right or wrong on the ultimate thing.
Understood. I think the answer to that is no, and it's because of Judge Wilkins' Rule 64 report. He issued that Rule 64 report to get appellate immediate review of his class certification order because he felt it was so important to the outcome of the case and how the case would try. Then, when this court ruled in its rescript, there was no direction to the trial court to entertain a renewed motion for class certification on a new or different theory. The rescript from this court was simply the class certification denial is affirmed.
I take
that
it
closed the door.
Well, I take it if there had been further discovery or whatever, and there had been further developments in the evidence in the case, then the court might have had some ability to permit a refashioned class action based on new developments, right?
That's conceivable, but I think...
Well, it didn't happen here.
Well, actually, let me change my answer. I apologize, Your Honor. The answer is no, because discovery was closed.
Okay.
The only thing that was left to be done was to try the case, and when this court issued the rescript from Bellerman 1, I thought it was going back to the trial court to try the case on an individual basis.
Right.
Discovery was done. And, the plaintiffs made a decision in this case to not move for class certification until all discovery was closed, fact and expert. So a renewed motion to certify a class was not within the scope of this court's rescript from the Rule 64 report from Judge Wilkins, and therefore it was improper for the court to entertain this motion. It was certainly improper.
That couldn't be done as a matter of discretion?
Not by the trial court. I think the trial court is bound to apply the rescript that comes from this court when there's a point in time where the trial court stops and says, this is so important, we need to get the Supreme Judicial Court of the state to say whether this is right or wrong.
Well, let's move on to your second argument.
Okay, all right, thank you. Second point is that the trial court, in certifying this claim for an overpayment, misconstrued the element of injury under 93A. And of course, let's begin with the proposition that this is statutorily required injury, and to certify a class, it must be shown that that is similar across the class. The class that Judge Tucker certified upon remand is quite different than that was proposed to this court 2 years ago. It's no longer tied to the storm. You may recall this was all about a terrible ice storm that occurred in December of 2008. Now we're told by both Judge Tucker and the plaintiffs in their brief the storm is irrelevant to this case, even though that's what the case had always been about since it was filed. The class is defined not as people who were impacted by the storm, but rather anyone who paid FG&E's utility rates for service from 2005 to 2009.
How did 2005 get picked?
I believe that is the statute of limitations window preceding the filing of the complaint in January of 2009. I think if the plaintiffs had their theory of the case without the statute of limitations window, they'd go back into the 1990s. And I think that's what they've argued in their brief. So what you have is plaintiffs, class members, who were not impacted by the storm, who moved away and were no longer FG&E customers at the time of the storm. You have customers who lost power during the storm, admittedly through no fault of FG&E's, as the plaintiff's expert testified when we took discovery in this matter. You have people who lost power and got it back relatively quickly, again, through no fault of FG&E. The answer that the plaintiffs have to this is individual injury is not required. That's what they're asserting, that the regulatory violation alone, that FG&E did not have an emergency response plan that was envisioned and adequate to deal with a major storm, such as the December 2008 ice storm, is enough to certify a class.
I thought the theory was that FG&E, that part of what was was the rate base on which the rate was based were costs connected with preparing an emergency plan.
Yes.
And that those costs and so that portion of the rate base was excessive because actually the plan was terrible or totally inadequate. And so the customers were overpaying for something that didn't work.
I understand that's the theory, but the issue is injury to class
But
members.
the injury is paying too high rates.
No, I think the injury is did you get what you bargained for? A customer who never lost power got what they bargained for. There's no defect in electricity. There's a lot of reliance by the plaintiffs on unsafe product cases, Iannuccino and Aspinall. Each of those situations involved a product, not a service, where the product itself was inherently unsafe. That's not what we're dealing with here. We're dealing with electric service. The customer pays a rate per kilowatt hour, and when the customer receives reliable service, this customer gets exactly what they bargained for. They've gotten the benefit of their bargain.
Well,
the only time there's an issue, the only time there might be injury, and this collapses us back into the issues of Bellerman 1, is if there is a major storm, if the company has to call upon that emergency response plan, if the class member loses power, and if the class member's restoration is not timely and efficient as it ought to have been. And once you get into that sticky wicket, again, we're back in Bellerman 1, and the individual causation issues that mean you can't have a class. Customers who never lost power got what they bargained for, and they are not injured.
It's sort of, I assume, it's a little bit like if the rate had included a warranty of continued service no matter what. And in fact, when there was a storm, some people didn't get continued service. And so the question is whether the warranty was, people who got the warranty, who paid for the warranty but never needed to use it were injured.
Correct, correct.
And you're saying that they're not injured.
They're not injured, exactly. And that's the teaching of this court's precedents. This court has been careful to tease out the injury element from the regulatory violation. And this court has addressed that on several occasions.
So Aspinall, okay, what's different?
Well, there you had an unsafe product that was advertised to be safe or safer than a regular tar cigarette. The injury was when the product was used as directed, and this is right from Justice Greeny's opinion. When the cigarette was used as directed, it exposed the class member to levels of tar and nicotine that the class member had been falsely told were not there.
But it
So
didn't
you're
require
ingesting that into your body.
you to get cancer in order to recover, right?
It did not require the development of a physical injury in terms of cancer, but the ingestion of tar and nicotine into your body when you're told that it's not there is an injury. That is separate and distinct from electric service, where if your lights never go out, you have no injury.
Except that you paid too much for them.
No, because if you got adequate service, you got exactly what you paid for.
Well, if
Well, but
that's
what-
assuming that's the only thing you're paying for when you're paying the rate for the service and not paying for the compliance with the regulation, that you also have disaster storm preparedness mechanisms in place that if perhaps weren't in place, but instead upped it to say you were doing that according to the allegations as I understand them, but actually diverted them to shareholders who actually were told, don't focus on that, focus on making money.
The injury.
Am I correctly
That's,
summarizing?
but
Yeah.
I view that respectfully, Your Honor, as the regulatory violation. And what this court's precedents have taught is that the regulatory violation alone is not enough. In Hirschenau, the car rental case, there was a regulatory violation where the car rental agreement had a clause in it that was barred by Massachusetts consumer protection regulation.
Right, but was there any evidence in Hirschenau that part of the cost of the, that part of the cost of the renting was somehow increased because of this illegal contract term? I don't think so.
I don't think that was discussed in the case, but the issue is what is the injury? And if a consumer receives adequate, reliable electric service, all of our customers who left the service territory before the storm, did, according to the record,
Well, I mean,
they don't have an injury.
This, I guess, segues into the DPU argument,
Yes.
which you're going to be making, but certainly at a DPU hearing, it would be appropriate to say, listen, Fitchburg, you asked us to charge X because you were going to provide not only electrical service, but you said that you were also going to diminish the risk of damage arising from a storm, and that you were going to spend X million dollars to accomplish that, and you didn't do that. That would certainly be an appropriate means for DPU going forward to said, you didn't, part of what you were supposed to deliver to the customers was not only electricity, but the diminished risk of harm arising from a storm, and you failed to deliver that.
Yes, and that's, I'll switch to my last point of error, which is the fact that this claim invades the DPU's function for exactly that reason, and the DPU here did exactly what Your Honor just hypothesized.
That's what I wanted to ask you, is when the DPU basically sanctioned your client, right, after the storm, was it somewhat, just what Chief Justice Gant said, was part of it was going forward, right? I mean,
Yes.
the rates requested were reduced because of this response to the 2008 storm.
Correct.
And was it based on the theory that, your rates before, A, you did a lousy job, but B, your rates before built in this money that was supposed to be developing the emergency response system that would work? Or just
Well-
was it sort of a fine, the equivalent of a fine?
I don't think it was the equivalent of a fine. It was a substantive evaluation of the quality of the performance. The DPU does set rates on a prospective basis. And the DPU did two things here, just to be clear. One, there was a special application for extraordinary expenses associated with the storm. There's a lot of out-of-pocket to the
Right.
utility to restore people to power, bring in outside crews, and pay those folks. The DPU disallowed about $7 million of FG&E's request to recoup money as a result of the storm, and they attributed much of that to the deficient response to the storm as a result of its investigation and findings. So that was a direct action by the DPU to adjust that.
If it had allowed it, that would have been built into the rate base going?
Yes. Yeah,
okay.
that's right.
So
That's right.
customers would have paid for it, in
Yeah,
other words?
and the DPU made the company take a haircut.
Right.
The other thing that the DPU did is that in the next rate cycle, rates are set on a 10-year cycle under Chapter 164, the DPU has the discretion to set the rate of return on equity. And it has a range within which it can set that rate, and it set it at the lowest level of the range. And based upon a substantive qualitative analysis of how the company did during the storm, and that is clear in the DPU's order.
So saying that the shareholders would take the hit rather
Correct.
than the customers?
Correct. So that illustrates that this is within the DPU's authority and within its jurisdiction. This court's precedents have not allowed private ratepayers to sue for overpayments or preferential rates.
So what do you say to the argument, how is Lowell Gas different? Because that was the Attorney General and this is our private customers, or is there more than that?
It's the Attorney General, these are private customers. Chapter 164, and I refer to Your Honor to footnote 9 in Lowell Gas. Chapter 164 actually envisions that the Attorney General would take action in the result of wrongdoing by a utility. And the footnote points out that Chapter 164 has a reporting obligation on the part of the utility to tell the Attorney General if something like that happens. So this court viewed that as authorization for an enforcement action by the Attorney General. The other thing I'd point out is it was actually an overt fraud on the DPU matter. It was not a claim of
That's what I wanted to
inadequate
ask you about.
service.
Right.
And I would just, I see my time is up, but I would close by just pointing to the late Justice Scalia's opinion in Central Office versus AT&T. And what he said there is that rates don't exist in isolation. They only have meaning with regard to the services that are provided for them. Any claim for excessive rates could be recharacterized as a claim for inadequate service and vice versa. And that's essentially what this is, and that's why it's within the DPU's framework. Thank you, Your Honors.
Morning, Ms. Phillips.
Good morning, Mr. Chief Justice, members of the court. My name is Deborah Phillips, and I represent the plaintiffs who are appellees here this morning. And if it please the court, I would like to review a little bit the issue that my brother raised about Judge Tucker's authority. I believe he was asked some questions on it. The defendants haven't cited anything for the proposition that the plaintiffs could not go back to the Superior Court and present another theory to certify a class. And
But in this case, class certification is critical. It was litigated fully before Judge Wilkins. Judge Wilkins made a decision. Everybody wanted him to report the decision because it was important to know how this case was going to proceed. This argument was not made as a basis for class certification. This court said, we agree with Judge Wilkins, class can't be certified, noted that there might have been another theory, but it wasn't raised.
correct.
Might have been another theory, but it wasn't raised. Why isn't that waived? I mean, Judge Tucker seems to say, well, the SJC says this is viable, so okay, all right, let's go with that. How can
Well,
that be a proper sort of?
I don't believe that there's any limit on how many opportunities you can ask the trial court to certify a class. And
Really,
this,
even after discovery is closed, you take your shot,
yes,
it goes all the way up on appeal, you come back and go, aha, here's a thought, how about another way of doing this?
Well,
No new
actually-
discovery, no new theories.
we did raise it in our brief before this court, and this court.
We noted that you
and
raised it, but
did-
unfortunately hadn't raised it.
Hadn't raised it below. This court said that in footnote 10, where a defendant's unfair deceptive conduct causes customers to receive a product or service worth less than the one which the customers paid, the customers may pursue a class. We believe that there's enough information already in the record from which we could demonstrate that we meet that. We
But
presented that.
Isn't your claim essentially that the company was unjustly enriched?
No, that's
It isn't?
no, well, that's a separate cause of action
I
that
know,
was
and that was dismissed
by-
below.
Correct.
So that wasn't a basis on which you saw class certification? That
No.
somehow there was an unjust enrichment by rates that were too high and they were...
No, oh, no. And we are not
Not
attempting,
your claim now?
no. Our claim now is that the service we received was worth less than the
And the company was
service
unjustly enriched?
than the service that the company purported to provide. The company is required to provide safe and reliable service. They have a public service obligation, as Judge Wilkins noted, as Judge Tucker commented in his decision. And they did not fulfill that, and we believe that there is enough information in the record to demonstrate that. As a result, the service that the customers were receiving did not comply with government-mandated regulations.
And
I-
people that received that service had no electrical power issues from 2005 to 2008 are members of this class.
Correct.
They had no problem with the service they received literally every bit of electricity they paid for.
Correct, as did the Iannuccino plaintiffs, had no problems with their car, as did many of the plaintiffs in...
But they had a physical object that was defective under federal regulations, a
Yes.
physical object.
Yes, and
that
we have-
diminished the value of their property.
Correct, and we have a service whose value was diminished by knowingly failing to comply.
How was the value diminished to those who received service and moved away? How was their
Because
value diminished?
they paid for something that they didn't receive.
Which was that? What did they pay for that they didn't receive? Services that were never necessary?
Well, they may have been necessary. I'll give you an example. If I'm a security guard or a part-time police officer, and I choose to buy for myself a bulletproof vest, and I use it, and I pay the price, and it says right on it, Kevlar vest. I buy it, I read online.
Defective product. You're saying this is a defective product in the same
I'm
sense that a
saying that it
defective
doesn't
vest?
comply with the advertising or the requirements that it was required to comply with. Safe and reliable service is something that they are mandated to provide, and it's not just a slogan.
And who's responsible for ensuring that they comply with? That's a DPU?
Well, yes, but they don't have the capacity to provide a remedy for consumers in this situation.
Consumers that got all of the electricity that they paid for don't have a remedy, you're saying? DPU can't provide consumers that got everything they paid for a remedy.
DPU can't provide a Chapter 93A remedy to
It can
consumers
reduce the
who-
rates, which it did, going forward to this large
That's
class of
prospective.
users.
That does nothing for the people who were paying the rates previously. Hirschenau, my brother brings up Hirschenau. Hirschenau, their comparison obscures the difference between the plaintiff's position in the two cases. Here we purchased electric service and continue to receive it on an ongoing basis, service that didn't comply with applicable safety standards. In Hirschenau, this court noted in Iannuccino that two things would have need to happen in that case in order for the plaintiffs to be able to have an injury. The car would have needed to be damaged during the rental period and the company's attempt to enforce the illegal terms. Here, all the members of the class paid for the same non-compliant electric service. Thus, Judge Tucker cited Iannuccino, page 631. If Ford knowingly sold non-compliant vehicles, if FG&E knowingly provided non-compliant service, the plaintiffs would have paid for more. We paid for more. In the case of the vehicles, safety regulation compliant vehicles. In our case, safe and reliable service that they were mandated to provide.
So in 2006 and 2007, I paid for electricity for 2 years, I've gotten it. You're saying the resale value of that was not, I mean, it's not like having a defective car where you've got to resell it.
I'm saying that logic would tell us that compliance is worth at least a penny. It's worth more than zero, which is what the First Circuit talked about in the Rule case, which my brother also raises as a case that assists them. That was the case of the heartworm medicine. It's a First Circuit case. There, the plaintiff, it was a motion to dismiss, but she brought her claim after she had purchased and used the medicine.
Isn't the warranty in Hirschenau worth more than zero? Isn't it worth a penny, even if I don't use it? Even if it's defective? I mean, no? I paid for the rental. It includes this warranty, which turns out is defective.
No,
I paid for
because
something-
nothing happened.
Right, nothing happened.
Well, you returned the car with no event. We continue every day to receive
And your clients got
that
electricity with no
service.
problem. and your clients got electricity for years with no problem.
No. Our clients got electricity that was not in compliance with DPU regulations in Chapter 164, as is mandated. We are like the Iannuccino plaintiffs.
Except
We are
that-
not the Hirschenau plaintiffs.
But doesn't it make a difference that the industries that you're trying to analogize this situation to are not regulated industries? I mean, there certain aspects of them might be regulated, but this is a public utility, and every aspect of what they do is regulated. That's what
Including
distinguishes
the
this.
price, including what you
The
pay.
price and the profit and
All the more
everything.
reason why
all
we
the
should.
less reason.
Electricity is a necessity of life in our society today. It's equivalent to the inherently
But the
dangerous.
DPU has been, I mean, the DPU, we just heard, it both imposed, it did this investigation, it charged the company, it has included penalties, essentially penalties in the rate base going forward. Why isn't that taking care of this?
Because previously, they were not in compliance with the Hurricane Bob order, and it was the ice storm that brought to light all of these non-compliance issues, all of the problems with their planning and decision-making. And to say that there is no value to those, one only needs to look at the order that they were required to follow after 0901A. They ordered a comprehensive management audit at their expense. It included strategic planning, staffing decisions, management and control of FG&E. They specified, we want you to look at FG&E. They made them pay for that.
But it still strikes me that if you're right, the result of this case would have a catastrophic effect upon the rate-setting process. And that's not in the public interest.
Well, actually, we don't think it would, because since this case, the legislature has amended the statute to provide more remedies.
Well, what remedies? Consumer remedies or Attorney General remedies?
Consumer remedies.
What?
Fines that will be deposited, fines for failing to comply.
Who
with
sets them?
The DPU. For
So-
failing to comply. There's now a process that consumers can go to the DPU. This process did not exist. The legislation actually was known as the Unitil bill. It's cited in the Bellerman 1
So
decision.
the legislature acted
They acted
to further protect the consumer.
because of the holes that were revealed by this situation.
They didn't enact a consumer remedy per se, saying from now on in, anyone who buys electricity that, from a company that hasn't lived up to all of their obligations shall recover, shall be entitled to.
No, it's a process, and it's set forth in the statute and the regulations that you can bring to their attention. And they actually have fined some companies.
I guess one problem I have is DPU told Fitchburg, you may charge this rate. How is it unfair or deceptive practice to charge the rate that DPU authorized them to charge?
That's not the unfair deceptive practice. The unfair deceptive practice is the fact that FG&E was not in compliance with safety and reliability standards and mandates. It's nothing to do specifically with the rate. It's not that the rate was.
But I thought the basic premise was, and the reason, the injury is that the people who are your class paid more than they got.
What we didn't get was compliance with a mandate that implicates safety and reliability, just like the federal regulations implicate safety with respect to the Ford vehicles.
So what would
That's our
that
analogy.
look like?
Sorry.
What would your clients have received under your analysis of noncompliance? What was missing from what they received? You said they're entitled to compliance. Well, what does that mean?
It means that the company was out there violating its tariff, violating the DPU regulations, yet we were paying for a service that was supposed to include that compliance.
But what was the concrete thing that your clients were deprived of? Is what I'm trying to understand.
I'm not sure that we have to have a thing. We don't have to have a personal injury. We don't have to have a tree that fell down or something like that. We overpaid. We should have been paying less.
Is there
It's
an issue?
overpayment theory.
Is there an issue of preemption that's lingering here, that's in the background? Or is there essentially been a legislative preemption of causes of action, private causes of action, with respect to injuries sustained as a result of the regulatory process in public utilities?
First of all, I don't believe so. Second of all, our complaint was filed before that, and the legislation was not retroactive.
No,
I don't believe
it's
that
a more
that's
general
come up.
question.
I'm sorry.
I think it's a more general question about whether in a highly regulated and rate-setting industry such as electricity, where the DPU does all that it does, is it just inherently, is there a preemption argument that, or I mean, I suppose now with the new statute, a primary jurisdiction argument, but in any event, a preemption argument that this is not for private consumers, it's for the DPU to take care of.
Well, I don't believe so, and Lowell Gas hasn't been overruled.
But Lowell Gas is the Attorney General.
Lowell Gas is the Attorney General because it was only the Attorney General at the time. The statute was amended after the Lowell Gas case to allow for private attorneys general.
In what, where? In which part, what are you referring to?
93A, I'm sorry, that was added after Lowell Gas. We are in similar shoes to the Attorney General with respect to competition or unfair, deceptive acts or practices within the meaning of Section 2 of Chapter 93A. And whether they only charged and collected the rates that were filed is got nothing to do with unfair and deceptive acts that they perpetrated on their customers. And we don't have a choice. I think Judge Wilkins emphasized that. I'm sorry, I'm seeing my time.
You can finish your sentence, but.
Is expired. I would just say that where their unfair and deceptive conduct caused the customers to receive service worth less than what they paid for, 93A has to provide a remedy. Thank you.
Thank you.